Good afternoon, everybody. We'll go ahead and get started. Welcome back to the noontime CLEs at the MJC. We took a little break over the summer. I'm delighted to have our one of my favorite speakers back to do our first presentation for the fall. Judge Eric Lippman is an administrative law judge at the Minnesota Office of Administrative Hearings. Prior to his appointment to the bench in 2006, Judge Lippman held a number of posts in state government, including his work as a senior policy advisor to Governor Pawlenty, state representative from Washington County, and as Deputy Secretary of State. In his remarks today, Judge Lippman will detail a series of best practices for those who litigate contested cases before the Office of Administrative Hearings, and his view from the bench could inform you how to prepare your next case, regardless of the forum. When he is not on the bench, Judge Lippman divides his time equally between his children's sporting events, volunteering with a local women's shelter, and planning his next trip to Israel. Please help me give a warm welcome to Judge Lippman.
Thank you so much. I certainly want to thank our great state law librarian, Liz Remke, and her staff and the state law library for their generous invitation to come and spend some time with you and to kick off the 2016-2017 CLE season. And clearly this is the premier event, so you'll want to keep that link to the state law library CLE page bookmarked and the top of your browser because these are the best courses and they are always and forever free. And so a great value to you and yours. So here in the Capitol Complex and across the globe via the World Wide Web, and today we're hosting 90 folks via internet connections, and I think that's only because it goes up to 90 or so. And otherwise I think there'd be more. And so it's a great resource for us to be together and to train together. So whether you're in this room or joining us via the internet by webinar, thanks so much for sharing lunch with me. It was great to go to lunch. I have a lot that I'd like to try and get across today. We've jam-packed this presentation with lots of useful tips and takeaways, but I'm saving some time, I'm hoping, at the end for questions and for dialogue. And so if my earlier presentation seems a bit rushed or I glided over something that you'd like to explore deeper, again, my hope is that we'll have some time at the end. So as things occur to you, if you have a pencil, borrow one from a neighbor, write things down. We'll come back to it at the end. And indeed, the discussion always is the best part. I'll start off, of course, with the standard government disclaimers. Being a loyal government employee, the views I express today during lunch hour are my own. They don't necessarily represent the views of my office, the Office of Administrative Hearings, my fellow judges, Governor Mark Dayton, or even my wife, as she informed me at breakfast this morning. So she totally disclaims the best practices would go about judging, and as she does judge in our house, in a very different way. We have a distinct roadmap this afternoon. We'll explore 5 key propositions, namely that there are specialized practices with contested cases, the ones that are referred by statute to the Office of Administrative Hearing. Knowing those specialized practices will save time and money and effort for you. I also think they're important because they'll improve your results if you know our local folkways. And even if you don't practice in front of the Office of Administrative Hearings or only episodically have a case there every now and again, I think that these best practices and the ideas that I'll talk about this afternoon will in fact inform your approach to case preparation and case prosecution or case defense in whatever forum you're in, wherever you are in the globe. Okay? So I think that these are a broader set of ideas, even notwithstanding the fact that they have special relevance for litigators and litigants who appear before the Office of Administrative Hearings. And being better, faster, easier, and cheaper, well, that's always good. It's a benefit to you, to your agency, to your client, to the things that you care about. I believe in an open book test. We always give the answers before the test. The best practices that I'll talk about today all come around 2 central themes. One, transparency. As an institutional value, I think our office, and me particularly as a hearing officer and a judge, I'm trying to contribute to transparency and open and understanding. My colloquial phrase is all cards face up. This is an important value, I think, in procedural fairness and procedural regularity. but it's shot through without it. And we'll come back to the idea of transparency and accountability throughout the talk today. Also, secondarily, but likewise important, is an efficiency in resources. This is a part of the exercise of self-government. We don't want to waste government dollars. We want to use our time wisely. And frankly, all of us have not only other work we could do, but other pursuits that we'd like to do. And so I think it's a credit to the hearing process if we can efficiently tee up the questions that we need to tee up and use everyone's time, money, resources wisely. These aren't just mine. I think that they're the founding blocks of the Administrative Procedures Act. Please, guys. If you start right at the very first page, 14.001 of the Administrative Procedures Act, it says that these are the objects for which the APA statute was originally enacted 4 decades ago, to provide oversight of the powers and duties delegated to administrative agencies. That's a transparency right? To increase public accountability of administrative agencies. Again, a transparency value. To ensure a uniform minimum procedure. That's efficiency. We're talking about efficiency in that respect. To increase public access to governmental information. That's a twofer, both transparency and efficiency. To increase the fairness of agencies in their conduct of contested case proceedings. Likewise, a twofer, both transparency. We know what government is doing. It's fair. And particularly with respect to the hearing process, and the hearing process is efficient and not burdensome. Lastly, and it's important to the folks who live and work in around this particular building, to simplify the process of judicial review of agency action by the state courts, as well as increase its ease and availability. Baked right into the cake is to make it easy for the Court of Appeals and for the Supreme Court. Okay, an important value. But it also gets back to our key ideas, which are transparency and efficiency. We want a clean and well-organized record because it contributes to either broader understanding by the public or understanding clearly of what's happened by any of the reviewing courts. All contested cases, which is the term of cases that are referred under the Administrative Procedures Act to OAH, start with a notice and order for hearing. I think a best practice for those folks, particularly the county attorneys that might be watching, or for the folks from the Office of Attorney General who are drafting a notice and order for hearing, is that your notice, in fact, provide notice. This is actually more difficult than it may well seem, but it's an important due process guarantee that folks who have a notice, a constitutional right to have a notice, an opportunity to be heard, in fact know what the claims that the government are making against them. It's often said, well actually before I get to what's often said, let me back up. A particular part of the Administrative Procedures Act, specifically Minnesota Statutes 14.58, make a statutory mandate that a contested case is only afforded and is afforded for an opportunity to be heard after reasonable notice of the issues involved, stated as soon as practicable. Now I've condensed some of 14.58, but those are the key ideas. So an opportunity for a hearing after reasonable notice, you'll know what the government is talking about, specifically with respect to the issues involved, stated as soon as practicable. Okay? So it's key that that the notice, in fact, provide some description of what the claims that are being mounted by the agency are against the citizen or the regulated party. Likewise, drilling down into Part 1400.5600, subpart 2D, requires that the notice and order for hearing include a statement of the allegations to be determined. Okay, so there's a constitutional right, there's a statutory right, there's a regulatory right, all for these things to be forthrightly described. How does this relate to our values? Let's see a hand or two. What are our values? Come on, I started this just a couple slides ago. Transparency. Okay, so if you have a notice that provides a list of the things to be determined, does that contribute to your transparency value? Yes. Okay. What's the other value? Efficiency. So if you have something that forthrightly states what the government is claiming, we're not going to be dickering about whether it's unfair surprise, right? And so again, the notice and order for hearing dovetails into the key things of what we're trying to accomplish in the statute. It's often said that there may well be a data practices problem because of the nature of the sensitive data involved in the allegations. I would suggest to you that that's the Minnesota Government Data Practices Act, CANARD. It's not in fact true. Minnesota Statute 13.46, subpart 4B1, paragraph 2, provides that the following data on current or former licensees or applicants are public: the general nature of the complaint, the allegations, even leading to those where there's a temporary immediate suspension for those folks who do human services cases, the substance of the investigative findings of the licensing or maltreatment complaint, the licensing violation or substantiated maltreatment, orders for hearing, findings of fact, conclusions of law, specifications of a final correction order, fine, suspension, temporary immediate suspension, revocation, denial, or conditional license. All of those are public data. So again, where there are, and I'll point to the human services context, particular data about child victims or unsavory allegations of misconduct, I think that you can do an appropriate balancing either by using initials or by stating generally that misconduct of a sexual nature happened on November 10th, 2015 in the afternoon involving a minor child and a caregiver. Okay. One, I think you could go further than that, but if you're concerned about the privacy implications, that would certainly, I think, is the kind of description that would put people on reasonable notice. Oh, I know what they're talking about, because there were only certain people at the daycare on November 10th, 2015 in the afternoon, and perhaps only a limited range of children. And if there's a problem, but that's much better than come to hearing, we'll tell you what the allegations are about. Okay? And indeed, not only for the constitutional, statutory, and regulatory problems is that problematic. I've cited in the materials the Hofker case. In that case, and the reason why I cited to you, I think it's particularly helpful, it's publicly available on Westlaw. So notwithstanding the ordinary case where many times the human services conduct, the data is private and the opinion is private, or retains a private data classification because of the nature of either medical records or child victims, that kind of thing. Hofker is in fact a publicly available case, and in that, former Assistant Chief Judge Johnson said with respect to supervision failures that were not either in the revocation order, so the penalty order from the agency, or in the notice and order for hearing, were out. Those incidents were not described in either the department's order of revocation or in the notice of hearing, and Ms. Hofker has never been charged with any license violation based on that. So that the agency couldn't proceed. So again, if you don't have a fair set of notice and an opportunity to be heard on allegations, they're literally coming from left field or the grassy knoll, there's solid precedent publicly available, in addition to, I think, very strong constitutional, statutory, and regulatory arguments that this stuff is not gonna go forward. So again, if you're in a position to be drafting the notice and order for hearing, I think it's important that you include enough kind of detail and make a better balancing than oftentimes occurs between legitimate privacy, rights, and expectations, and the need to inform the respondent in that particular case of what the government is claiming. And I think that through some artful drafting and taking some time, and not just a blanket, we'll let you know later if there's a protective order, is not well taken, not in our best tradition, and is not going to go very far with the ALJs. I'm a big believer in pre-hearing conferences. I think that there are lots of benefits for them. One, because somewhere between, depending upon how you count, a quarter and a half of the cases that proceed to OAH are with a litigant who is not represented by an attorney, a pro se litigant, that it gives an opportunity to orient that person to our hopefully open and accessible process, but still more formal process than they might ordinarily imagine. And so that's an opportunity, rather than to have someone arrive at hearing and expect them to be Perry Mason. An early pre-hearing conference gives me an opportunity as a hearing officer, as a judge, to say, this is what discovery is about, this is how we're going to handle documents, this is how You can watch our 8-minute video on our website, and we're very proud of that. It shows you a little role play about how questions, both direct and cross-examination, occur. Here are other resources for legal aid, low cost and no cost legal aid services. All sorts of benefits to orienting the pro se litigant occur at the pre-hearing conference. Really are really too late for Dodge if you wait to see the opposing party for the first time at the hearing. Likewise important, and because the law favors settlement, it's a gateway to alternative dispute resolution, to settlement talks. Oh, I really just wanted people to understand about this, or if you rescind that part of the correction order, I can live with the rest. It's a huge savings of resources if there's a fairly minor point that can be easily or not without difficulty resolved, which will save you all of the hearing expense, amassing witnesses, assembling exhibits, all of the litigation costs, and you won't know that in many cases if the first time that you're meeting the opposing party is at the hearing. Again, it's a possible approach, but I don't think it's a good one. And so really, in my view, in every case that's not a temporary immediate suspension, and the only reason I carved that side out is because the time frames are so short. You're going, a hearing in 10 days or something like that, that a pre-hearing conference is a must, really, as a best practice in your case. And even, it's worth considering if you have good contact information, people have cell phones and emails, even to have a pre-hearing in your TIS. This is what's going to happen at the short hearing. We're going to have all the documents that we need, all of that kind of thing. So I just think it really saves you a lot of time, and it's very very beneficial. Oops, sorry. The alternative to planning in that way is risk. You don't know what documents are coming. You don't know what witnesses are coming. You don't have any idea about the settlement position, whether a hearing could have been easily avoided. You don't know any of those things if you're just steaming off to hearing, and you don't know if the pro se litigant is particularly unprepared, whether the judge isn't just going to reschedule because of the equities of the situation. Well, I didn't know I needed witnesses. I didn't know I needed documents. Well, if you didn't have a pre-hearing conference, that kind of orientation can't occur, and there's a solid argument. I mean, if you're the government attorney and you want to proceed on that day because you've done all of this planning, well, it says in the notice you're supposed to do this. Okay, and you may well be right, but whether the equities or fairness, or particularly the judge's contemplation of whether the pro se litigant has a fair opportunity to know what the allegations are and to be heard on those, I think it's a risky balancing, and it's one that doesn't necessarily benefit the agency. Also, and again, for the safeguarding of trial resources, if you in fact can settle this case easily, or there can be some other appropriate resolution, you don't necessarily have to bring your people in or spend the time preparing them or the exhibits for trial. The other important piece with respect to safeguarding trial resources is that if the other side shows up, actually if the rule works both ways, both in the Revenue Recapture Act, and that rule is 1400.8560 for those folks who do human services cases, and for the regular contested case rule, the rule is 1400.6000. If either side shows up or doesn't show up, the government agency or the respondent litigant, the other party who attended the pre-hearing conference can move for a default. The other side doesn't care. Okay, and so if you're the pro se litigant and you show up at the pre-hearing conference and the government agency does, you can ask that the case be dismissed against you. That's a huge set of benefits for trial resources, so government attorneys show up at the pre-hearing conference. And again, it's permissive, it's may, but likewise, the extent of preparing for a pre-hearing conference, which is usually having your calendar ready, and maybe the calendars of your witnesses ready, and preparing for trial, very different. And if there's a good reason, the person has fled the state, they're never coming back, they're not going to answer these charges under any circumstances, why prepare for trial? Move for a default on the pre-hearing conference, a huge saving of resources. So again, thinking about our values, what would that respond to? Efficiency, a great efficiency value, because you just have to prepare for the pre-hearing and not for the full-blown trial. Key timing issues. Again, talking directly to the folks who do human services cases, an oft ignored or maybe honored in the breach would be a more charitable way to say it. Many busy county attorneys aren't mindful, as well they should be, of 245A.07 subdivision 7, which has very demanding timing rules for the human services cases. 15 days from the appeal from the respondent, so your daycare provider, your adult foster care provider, your child foster care provider, those kinds of things. 15 days from the appeal, they want to challenge a correction order, an order of revocation, or something like that. There's a statutory mandate that you ask for the hearing process. So again, 2 weeks after you get the appeal, you've got to ask for and issue a notice and order for hearing. Okay, so that's a statutory prohibition against this file sitting on your desk. Okay. Moreover, once the notice and order for hearing is issued, it's a 90-day clock to hearing unless good cause shown. So, as sometimes happens, the file sits on a busy county attorney's, assistant county attorney's desk. It's well past 15 days. They call up sometime thereafter our office. They issue a notice and order for hearing. They put maybe a pre-hearing conference, maybe not, but on for, say, 60 days into the 90-day period. You've just blown a whole lot of time within that statutory 90 days. That makes a genuine rush once you get to pre-hearing, unless there could be good cause shown. And frequently the argument will be, well, Your Honor, you can find good cause. We just can't get to it in 30 days because we wasted 60. That's the implied premise. And that's not a really great argument, only because the good cause rule in 1400.7500 says that good cause does not include the failure of the attorney or representative to properly utilize the statutory notice period to prepare for a hearing. So you put the judge in between sort of due process and fairness and the direct text of the rule, and that's a bad foot to start off on. Let's just say that. So much better to realize the statutory imperatives, to count 15 days from when you get that respondent's appeal, to get in and have an early pre-hearing conference. Let's use that 90 days, as much of it as possible. And the conferences are short, and they can be by telephone conference call. We have a toll-free number just for that purpose. So you don't even have to leave your desk. So sometime within the next week, let's get this trial, at least the preparations, going. Let's orient the respondent litigant. Let's talk about when pre-filing of exhibits and these other things are going to happen. Let's see if we can settle this case. Wouldn't it be nice? So we're using that 90 days wisely. So that if later, if something goes sideways, well, we know that it's not the failure to properly utilize the statutory notice period, that we're extending it out another 90 days. So you make a friend out of your hearing officer because you did what you could to use the first 90 well, rather than saying, well, I just, we got stuff to do. And I realize you got stuff to do. But that's an argument for the folks over there, not on Robert Street over here. The legislature had an expectation that these cases would move at a different speed. Likewise, there are similar ones with special ed. I'll just touch on them briefly. 5 days to a pre-hearing conference in a special ed case, so you've got to be in very quickly. And again, this is a Minnesota-specific practice because the legislature wants lots of planning and orientation for particularly pro se litigants and parents in these cases. And then it's essentially a 75-day period after the filing in the ordinary course for those cases to be resolved, so very quick. Similarly, in the order to show cause cases where they're going after a particular business to shut them down that are regulated by the Department of Commerce, it's 30 days to a notice and order for hearing under 45.027 and 30 days to a hearing after that. Again, quick time frame. In the campaign cases, if it's a complaint related to an ongoing election this current season, it's 30 days to hearing from filing of the complaint. And so be mindful of these time frames and try to do some early planning so as to use your time wisely and you don't get caught. What are some of the items that should be resolved? Pre-filing of witness lists and exhibits, any accommodations for witnesses that might well need, the dates for the case milestones, if there's going to be an exchange of expert statements, or there's going to be motions for summary disposition, our version of motion for summary judgment. We want to build in time for that. And so thinking about the calendar, and again, this relates to both of our values. What are both of our values? Come on, who are the A students? Transparency and efficiency, both of them, okay? All cards face up, you know what the calendar says, and efficiency is we planned out the calendar in ways that we're getting the work that needs to be done, and we're focusing on it in particular intervals. So again, this really does respond to what we're trying to accomplish. Let's talk a little bit about discovery. In the ordinary contested case rules, 1400.6700 subpart 2 provides that any means of discovery available pursuant to the rules of civil procedure are available at OAH. So if you have a contested case, you like to do depositions, you like to do requests for admissions, interrogatories, any of those processes, even a site visit, is available through the contested case rules. The Revenue Recapture Act, okay, so if you have an administrative penalty order, it's an environmental case, or it's the human services cases, there isn't the discovery, okay? Two-edged sword here. So the only discovery that's available there, as a matter of right, are a demand that the other party disclose the names and addresses of all the witnesses, and that's under 1400.8600 mentioned there. And that response is due within 10 days. And also there are powers under the Revenue Recapture Act for the ALJ to make the specific rulings on discovery issues. So it might well, in the ordinary course, be turning over the agency file. That's, I think, an important piece there. But very limited kinds of discovery. Indeed, the Revenue Recapture Act's rules presume, unless there's another order from the judge, getting back to our pre-hearing conference idea, that witnesses or parties would bring their exhibits to the hearing. Now, I think that's no way to run a railroad, because there can be all sorts of problems with just folks arriving on the day of the hearing with their materials that the other side hasn't seen, hadn't had a real opportunity to examine. And so again, I think this dovetails back into the idea of an early pre-hearing conference. We can get a discovery order, or at least a pre-filing of exhibits at a minimum, so that a week ahead of time, before you go to a hearing, you could at least see what the other side is going to offer and to know if there's problems. What if, God forbid, there was a claim of forgery for or alteration, some sort of misconduct, with an exhibit that an opposing party brought on the day of the hearing? That just sends the whole hearing process sideways. If you had pre-filing a week ahead of time and there was a problem with Exhibit B, that's not the original. That says something different. You have a week to confer with the ALJ, get a conference, have some examination of these materials. All of those things are sorted out. You can preserve your hearing date, all the planning that you've done around that on your calendar, your witness's calendar. But like I say, that goes right into the ditch if you have a serious problem under the old rules. Now again, maybe the Revenue Recapture Act assumes that these are smaller cases and it's not, a problem like that isn't going to happen. But if you're the daycare licensee, if you're an adult foster care licensee, if you're a construction company that has a pollution discharge case, this is a big deal. This is a big deal to you and your livelihood, your company, your source of revenue. And we're not going to be particularly casual when it comes to due process rights or clarity of the record. That's my job, is to take care that the administrative record is clear, not only because I have a sort of trust duty to the litigants to do the best that I can, but also because it dovetails back into the key purposes of the Administrative Procedures Act, which is to make the record open and accessible for later review, if necessary, by the state courts. So again, these things build upon each other, and to have the early planning and to be thinking about your case ahead of time is much better than trying to sort these problems out when the options are fewer on the day of hearing. Thinking about hearing exhibits, I like sensible labeling conventions, either a range of numbers, I'll give one side in particularly document-rich case 0 to 100, the other side from 101 on to 200. In the smaller document cases, I give one-party letters and one-party numbers. I think that, again, just so that I could see by the label who's responsible for it and who's offering it without a detailed review. I think that that's helpful. Having the right version of documents, really very problematic for you to have offered Exhibit 13 into the record and either the licensor or your expert or witness is using a different version that they've annotated with different facts, a prior memo, a later memo. That certainly interferes. Well, what does it interfere with as far as our values? If your witness is testifying off something that the other side hasn't seen and isn't properly introduced or marked, what values does that interfere with? Transparency, clearly transparency. Okay, and if we've got a transparency problem, what also do we have? And a huge efficiency problem. God, you guys are unbelievably smart. How did we get such bright people? But you can see how these things are all related together. You have a problem like that with not having one set of materials where there's all cards face up. And that's clearly a not all cards face up problem, because the witness has something very different that he or she is working off of than the rest of us. Not a good thing. And it really goes central to the core purposes. And so everything stops in that hearing room. 4 copies, I think, is really important. Yours, mine, theirs, and ours. So your copy, the copy for the judge, the copy for the other side, and I think a copy for the witness. And so I'm very mindful, again, in the Revenue Recapture Act, a special note to the folks who do human services cases, you are absolutely right. The rule only says enough copies for the other side. Okay, if you want to be scrupulous about of the rule, it says one other copy, my copy and their copy. But if the witness, you're going to ask the witness a question about that, and we have to fumble around, or if I have to give them my copy or not have a copy at all, what does that interfere with? It certainly interferes with efficiency. What also does it interfere with? Transparency, that's the other one, okay? Not everybody knows what's going on. Or what are you reading from? Well, I only have to do one copy. Okay, so imagine a situation, 2 alternate scenarios. One is somebody did 4 copies of their exhibit, and it's true, they have an extra paper cost and they have an extra toner cost. And there's some staff time of running it through the sheet. Okay, so that's cost number 1. Think about all of the attorneys. Maybe it's a court reporter, maybe it's the other parties. It's time in the room. It's all the hearing costs, dickering over whether we should have an extra photocopy. Which one is expensive and which one is inexpensive? I would suggest to you politely and kindly and earnestly that the extra cost of the extra copy, in comparison to dickering about well, certainly making a 1400.8604 argument at some length. And the idea that even if you are particularly right and you get a bonus point, a gold star for being able to recite the rule, by running headlong into our transparency and efficiency values, you might be just too clever by half. And so I think it's really good to have the extra copy. Plus, it also suggests another thing which is really good for whatever side you have, which is that you've thought through all of these things in the run-up to trial, even contingencies. No problem, Your Honor. I have an extra copy. Man, I'm just all smiles when somebody says, no problem. It was going to be a problem. I'm not somebody who, I'm interested in transparency and efficiency. It's true, the rule only says 1. But we're better than that, right? Okay, you're moving beyond just the minimum to the best practice. I'll also mention a recent innovation. The standard pre-hearing order that you get from OAH now provides that you send a paper copy to the tribunal if you have either e-filed through our wonderful new electronic e-filing system your hearing exhibits, or you sent them by way of fax. And people do send, in order to make the timing deadline, you're trying to hit that pre-filing deadline of 4:30 a week ahead of time. People are faxing or they're e-filing. But if it comes in one of those electronic methods, our standard order now provides that you also send a paper copy of the hearing exhibits, because we're taking those and we're going to take that to the hearing. Okay? Again, yours, mine, theirs, and ours. Let's talk a little bit about pretrial preparation. I think it's important to know the legal standards for your case. Maybe that seems too elemental, but know what you have to prove and how you're going to set out to do that. That's really very important. I hate to have to say that to such a clever audience, since you remember our values, that you probably don't need this reminder. But again, I think it's very important to think deeply about when you're doing trial preparation exactly what the statute requires you to do and your role in it, and particularly your method of doing that. I'm going to make an argument for a short opening and contradict the idea of what I call misplaced courtesy. Oftentimes we'll get the case where, no, Your Honor, I'll waive opening. We'll save time on the argument. Maybe they've foreseen this lecture, for efficiency. I'm not going to bore you with what we're here to do today. I suggest that that's misplaced, because while you may well think that you're being kind and courteous of my time, that I'm eager not to hear your thoughts on the case, and that we can just launch into witnesses, it actually telegraphs a very different messages, whether it's intended or unintended, which is I get the feeling that you don't have enough command of your case to make it simple. My very favorite quotation is George Bernard Shaw, who, writing a long series of pages to a dear friend, correspondent of his, says, I'm sorry this letter is so lengthy, I didn't have time to write a short one. And I think that particularly lawyers and anyone in the communication business should really, really try to take the time to write a short one. Okay? You know enough about your case that you could summarize at least the equities of it, or your particular position on the elevator ride up. And again, it doesn't need to be particularly dramatic. I'm not calling for everyone to be Clarence Darrow. You can say, Your Honor, we think that the evidence will show A, B, C, and D, and that's a very fine opening. But it telegraphs and I think emphasizes that you've thought that you've got 4 things to do in this case, A, B, C, and D, and you're going to fulfill that promise. If you're oriented around that, and again, it doesn't take that much time, I think you've done yourself a real world of good. And that this other courtesy that I can't listen to 2 minutes of A, B, C, and D is misplaced. I'd really rather have it. It's a 2 minutes well spent, and it tells the respondent what's going to happen. A particularly helpful thing if they're a pro se litigant. The government is going to establish the order of revocation is well placed because of this statute and that regulation. And the licensor saw that kind of misconduct on this particular day, and that's what we think the evidence will show. Okay, now we know we're ready to go, and you're ready to go. So very important on the messaging. Let me talk about the special rules of evidence. We oftentimes say, oh, Your Honor, you don't have hearsay rules at your tribunal. It's Wild West. It's all informal. It's all good. Not the case. The rule, that's an overstatement of our relaxed, genuinely relaxed hearsay rule. It's and it's 1400.8607, and there's and that's in the Revenue Recapture Act rules. And for the contested case, it's 1400.7300. So in the Revenue Recapture Act, it's even sort of more generous, but I think it rhymes certainly with the contested case rule, which is that we can admit evidence that logically tends to prove or disprove an important fact, including hearsay, and then many people stop reading. But the most important part comes later, if, there's a huge if there, if it's the type of evidence upon which reasonable and prudent persons are accustomed to rely in their conduct of their serious affairs. And so what that tends to lead to as a practical matter, if you wanted a practical shorthand, is that official reports, government documents as to which the authenticity cannot reasonably be questioned, can come into evidence without a sponsoring witness. So a police report documenting sexual misconduct of a daycare child, you don't necessarily need, or you're probably not going to need, to have the officer or the custodian of those records come in. The Scott County Sheriff's Office report on that matter, that's coming in because it's an out-of-court statement. You got that right, but it's one which reasonable and prudent persons would be accustomed to rely in their conduct of their serious affairs. the third degree, fourth hearsay of a report that says somebody unidentified who asserted X that's really very useful in your case, that's not the same thing. Not double or, it's not an invitation for double or triple hearsay. One, because it's not particularly transparent. I can't cross that person. And it's not particularly efficient because we're arguing several layers of who knew what when and whether that has indicia of reliability. So not only is it beyond the rule, you know it's wrong because it strikes at the heart of our values. Okay? And the reason why I get back to, I should make the point because I'm not sure I made it clear earlier, the reason why I keep coming back to these two central values is, at least for the attorneys in this room, you're going to be making arguments on procedural matters. If you can either make an argument or at least prevail solidly, ground your argument in not only in the text of the rules, but also that this contributes to what we're all about, transparency and efficiency as subsidiary values. Not over due process, but they're also important supporting values. You're really doing yourself and your client a good deal of good. And I've suggested that that textually scrupulous, albeit violent applications to the underlying values may well win, but that's rougher sledding, as I've described. The one copy rule. Okay, yes, it's true. It does say one copy, but is this really good for the hearing process? And there are dozens, perhaps hundreds of other kinds of examples that you could make. And so think not only about the black and white text of the rule, but how it fits into these larger values of the Administrative Procedures Act and what it is that we are set out to do. Hearing room practice. I think the good qualities in a hearing room are that they're accessible, that there's enough space. Again, for a small daycare type hearing, where there's a couple of folks, maybe 8 or 9 people. If you had a room for 15, you're not feeling so cramped. Okay, so if you're expecting 8, plan for 15. And for something where I prefer a room where where it's not in the office of one of the parties. I will frequently move a hearing location. The county attorney will set it in their office. Well, gee, that's convenient for one side, but is it going to be open and transparent to the other side? You wouldn't want to go to the other litigant's conference room to try your case. So to try and have a more neutral location, I think that this adds to not only our efficiency, you're not squabbling with the judge, but also the overall atmospherics of transparency that we've picked, in the example of a city or a county, one of the conference rooms that the county board might use, but doesn't need during the day. It's not our side, it's not your side, and so we're meeting somewhere in the middle. Likewise, stipulations ahead of time on exhibits, and again, it dovetails with the idea that you'd want to meet your litigant before the hearing. That's very helpful. And to the extent that 1 through 15 can come in, we have some debate about whether 16 is appropriate. We can get to that, but you saved all sorts of time on 1 through 15. Again, a huge boon to efficiency, one of our core values. And likewise, knowing time certain arrangements. Your Honor, the licensor is not available on Thursday, but we can call her at 11 o'clock on Friday, and we have those arrangements and that early stipulation with the other side, and we're all good to go. You're not going to get an objection from me. I don't mind extending the time for a party to rest their case in chief. If we're getting a witness out of time, again, I'm interested in transparency and having that person to be a part of the record and understanding it as best we can, and also efficiency. So the courtesies that we give to each other come round. We live in a world of karma. You're nice to the other side, they have occasion to be nice to you if you needed an accommodation on your side. Post-hearing writings, there is a page limitation in the rule. I'm the judge least likely to enforce it because I'm of a view that if you're willing to write it, I'm delighted to read it. So while there is a 25-page limit, other members of the panel will be more scrupulous, not me, on that piece, with one important critical overriding caveat, which is I'm making an essential balancing on post-hearing writings in every case to understand whether the resources between the litigant and the government is not always the wealthy party. Sometimes, I have many cases where the government will say, geez, we're beleaguered government agencies, the Acme Corp is colossally rich and has, legions of lawyers. So it's not always that the government is the rich party. Sometimes it is, comparison to the respondent, but sometimes it isn't, decidedly so. So I'm making a resource calculation, which is the arrangement of post-hearing writings, notwithstanding my delight to read it, fair as far as a burden on the parties, and so I'll be making kind of a calculation. So rather, oftentimes it's not a 25-page brief, but it's a five-page single-space letter brief, which again gets back to our George Bernard Shaw idea. To write in a fairly complicated case, to write 5 letters, you really have to write a short one, and so it has to have command of your ideas. But I think, again, in sort of an all cards face up and efficiency and due process fairness, that balancing is really the key criterion. But again, having more information rather than less, I love it. That's great. You're not going to have any complaint with me. But think about it from the other side's point of view, in addition to your own resource needs. We're almost at time for Q&A, so let's do a little bit of brief recap. The best practices do reflect our key values. Who knows what our key values are? Is anybody paying attention? Who knows? Transparency and, all right, star students. All the things that we're talking about as far as pre-hearing conferences, as far as discovery, as far as planning your case, as far as preparations for hearing or after, all reflect the ideas that we want all cards face up, and that we want to use our time well and efficiently. And these all go back, the headwaters of this are in the very first words, the very first page of the Administrative Procedures Act. We're about accountability and transparency and access to government information and clarity of the record and uniform procedure. All of these things dovetail from the very purpose of setting out these kinds of procedures. There is a distinct and important method to this variety of madness. There are specialized rules of procedures in contested cases. If you know them and you think about them ahead of your next contested case, it'll save you time and money and effort. And I think it can also improve your results. You'll have better solid arguments that really are rooted in the best traditions of the statute. And even if you don't come to our office to litigate, I think if you think about transparency and efficiency, because this theme is common to every beleaguered tribunal, there is wherever it is that you practice. So Campaign Finance and Disclosure Board, the state courts, federal courts, the federal administrative law, wherever you're for the local city council. If you can mirror the ideas of transparency and efficiency, you'll be a more effective advocate with better results. Because being better and faster and easier and cheaper, well, that's always good. I have one excellent piece of news confirmed this very morning. You have just earned an hour of general CLE credit. The number is 228896. I can't remember a prettier, more wonderfully sounding number than that. And with that, I'd like to open it up to questions. Should we take one from the web if there is one?
We don't have one.
Don't have one yet. Anyone here? Rebuttal?
Well, I have a question. This kind of goes to what happens after. This is the judicial review part. And, in terms of transparency, I don't know whether you're familiar with 14.63 and 14.64, but how you get judicial review, I think those statutes are a mess. They're very confusing. There's not only just for pro se litigants, but for represented ones, as to how to get to the Court of Appeals, what you have to do, what the time period is.
Sure. I think that, and the question is, I'm interpreting the question as to talk about the special risks associated with appeal from either an OAH final order or an agency's final decision where we've made a recommended decision for later review by the state courts. And I would agree with you. I think that there is special risk with the timing related to writs for certiorari. And because there are two different and distinct timeframes, one a 30-day and one a 60-day timeframe, And if you make a mistake on that, that has a big impact on what's going to happen later. I would encourage folks to read very, very, very scrupulously the rules of civil appellate practice if they had a decision that they're thinking about taking up. And likewise, Chapter 14 and the published case law on the cases that did not make it in time, sometime by as little as a day, on time, beyond the appropriate and applicable statutory period. So I guess as far as I'll go on that is I concur that there are risks for and traps for the unwary, and that you folks should all be very wary, and that if you're thinking about an appeal is to know exactly what lane you're supposed to be in, and to have that backed up with solid reference to case law and statute. And good luck and Godspeed.
Couldn't OHH, I mean, do you have any interest in, going to the legislature to get them to simplify the process, and also to, put explanations, maybe in the final order, this is what you have to do. I mean, it's kind of hard to explain because it isn't just a time period, it's what you have to do. I mean, 14.64 talks about serving the petition by certified mail or personal service, which is a variation from what you usually have to do to perfect an appeal. And so, I mean, it isn't just the time frame that's confusing, it's, the specific requirements for perfecting the appeal that's confusing. But I'm just wondering, you've got a lot of clout with the legislature. I mean, if you went to the legislature and said, we need to simplify this, it's not transparent, it's not efficient, I bet they would do it.
Okay, so just to repeat for the folks on the web, the suggestion is that OAH could contribute to its public service and public spiritedness role by advocating some clarifying amendments to the appellate rules, or at least the appellate procedures, the statute, with respect to the timelines and the requirements for perfecting an appeal from an agency decision or a final order. I will say one thing, I'm fairly surprised that there would be a reason to appeal an OAH final order, but assuming that would be the case, no, I'm only just kidding. That actually there is some precedent for this, which is that we did ask the legislature to make a modest change with respect to the service. Originally, in any final decision where we were the final decision-making body, there are some OSHA cases, there are special education cases, there are the campaign cases where we're not standing in the shoes of another agency, we're actually entering a final order. That in those cases, the prior practice was that OAH was joined as a respondent in the litigation. So it's X versus Y and OAH. And so, we were regarded, it was like I think taking the referee as hostage. We didn't have an outcome. If we had made the correct decision, we're delighted. If we'd made the wrong decision, we're eager to be instructed. But we're not a partisan in either of the legal positions. We certainly didn't want to have a brief. And so the legislature did adjust that statute so that the service requirements now are just on the party opposite and not necessarily on OAH. But I will make a half effort by telling the chief that you think it's a very good idea and would contribute to our esteem and public reputation and public service if we had some conversations with the legislature about streamlining the statute for the admittedly rare and remote idea when we ever made an error. But and I'm only kidding on the last part. But like I say, I think it is in our best traditions to be helpful. Please, Councilor.
Thank you, sir. I've had a lot of experience with energy projects where there is a very robust administrative hearing process. Most of the work I'm doing now pertains to either the Pollution Control Agency or the Department of Natural Resources that are making very important decisions and they are, in general, exercising the discretion to have no contested case hearing process, no matter how complicated the facts are. And I'm wondering, first, if you have any comments about the agency's discretion to utilize these processes to increase transparency and efficiency. And also, if they were to do this, whether the administrative process might be sort of improved in terms of the quality of the decision making and the at least the comfort to the community that evidence has been the deciding factor.
Okay, so let me go back to my standard disclaimer. I'm speaking only on my behalf. I'm also going to distance, and I'm not making any reference to any case that might or might not happen with respect to mining interests or other things which might be north of 94 in particular. But just generally, my own view is that I think I'm very proud of the office that I work for and the work that I am privileged to do. I think that we make a contribution to transparency and to efficiency, particularly in complicated cases, because of our practice and expertise in developing a readable and clear record where even if you disagree with the conclusion, you can see the particular math that we go through and how we arrived at the result. I think that is efficient, particularly for multi-member boards, but also for commissioners who are making policy decisions. I realize it's more complicated than that because there is a budget impact, but I think that that for the amount that we charge, and that we're a revenue, a revolving fund, we do bill the agencies that we work for a standard and low hourly rate compared to, if you were to compare the legal experience of the people who are doing this work and rates that are routinely charged in the private sector, or even in the nonprofit sector. We're unbelievably competitive, and I would suggest a bargain. But I think that agencies should think more often about giving us a wider range of useful things to do, because we write really good memos and help in the agency branding in building public confidence. Now that's not with respect to any particular case, but we work for 120 different jurisdictions, state and local agencies across the state of Minnesota. I think that we have fulfilled a lot of the purposes that the original drafters 4 decades ago of the Administrative Procedures Act hoped for. And indeed, for the 2 or 3 that are remaining, they would confide even more than they originally hoped for. And I think that that's a good thing and is always something that the agency should think of. We have one last question from the web.
Yeah, how do you try to rein in counsel that try to take over a hearing as informal as OAH's?
The question is, how do I rein in counsel who try to take over a hearing when they're sort of informal procedures? And again, I think if you're on the business end of that, I think a subtle reminder that the judge is driving the train or is an effective referee. And again, going back to our values, you know, counsel's constant grandstanding, one, is not particularly transparent, doesn't lend to that value, and it's really not efficient. We're burning a lot of hearing times with X or Y's tirade about these kinds of things. Okay, and so I think those kind of gentle reminders, but not with returning in kind in your own, I don't know, there was a political figure, actually several political figures this evening, who said, when they go low, we go high. I think you can go high with, our best traditions are about transparency, all cards face up, and an efficient use of resources, Your Honor. Counsel's extended diatribe isn't either. And with that, I'm hoping that you'll follow me on Twitter, and better still, do yourself some good. Keep in close touch with the State Law Library. Free CLE is the best learning that you can get for the price. Thank you. Keep in touch.